I'll start out with a little bit of an intro and background. Personally, I'll just put in a few interesting facts about myself. I am a triple citizen. I have citizenship in Iran, Canada, and the United States. I've lived in 4 different countries. I've visited 30 different countries, and I have scuba dived in 5 different countries. So that's a little bit of background about me. Today's presentation is going to be about contract law. Now, obviously, contract law is going to be a primer. So you'll get to know a little bit about the basics of what makes a contract. All right, so basics of contract law. I think consent can be broken down into offer and acceptance. So it's when somebody offers to do something for you and you accept it. The third piece is there's intent. So they want to enter into that contract. And then finally, there has to be consideration. So you can't, if you do something for free for somebody, that's not exactly a contract. So these are the 4 main elements. Now, there's a lot more that goes into it, right? So there's reasons why contracts can be invalidated. There's reasons why contracts can be breached. So there are other items here, and I'm just going to put the additional ones here. So contracts can't have a purpose that's in violation of public policy. And we'll get into this a little bit later with non-competes. You also, both parties need to have capacity in order to enter into that contract. So by capacity, we mean, they need to be of sound mind. It can't be somebody who is, on their deathbed. It can't be somebody who has been declared mentally incapable of entering into a contract. So that's what we mean by capacity. And there has to be mutual assent. So this is the meeting of the minds. They, intended to, it goes back to the intent issue. They intended to enter into the contract. They, the parties collaborated over the contract, and they had a meeting of the minds and mutual assent to enter into it. So those are the basic 4 elements, plus the additional, there are more than these 3, but these are the 3 that are going to be valid for this discussion. Okay, so there's this thing, it's called the Statute of Frauds, and it dictates when a contract must be in writing. Now, obviously, sometimes you enter into contractual relationships orally, and we have plenty of clients who come to us and say, hey, I had this oral agreement with somebody and they breached it. And we sit down and look at it and say, hey, look, you should have gotten this in writing. So when are the cases that you need to get these in writing? Now, it varies from state to state. So this is kind of a general overview. So if you're in Virginia or if you're in Atlanta, or New York, New Jersey, make sure you double check the state statute on the Statute of Frauds. But in California, the basic elements to the Statute of Frauds is that any contract that by its term cannot be performed within 1 year must be in writing. Any contract in which a party is promising to pay the debt of another must also be in writing. Leases of real property for terms longer than 1 year, real estate agency or broker agreements, contracts to purchase real property, and contracts to loan money or extend credit in excess of $100,000 or more. So all of these need to be in writing. This is not an exhaustive list. There are other types of contracts that also need to be in writing, but this is the basic. So the master service agreement governs the terms of the relationship between the service provider and the customer. The MSA or master service agreement is almost always used in combination with a statement of work. And for example, the statement of work might cover, 2 placements at a company for 1 year. And the relationship of having those placements in that company for a year and the client, it will be dictated by the master service agreement. So then let's say that that customer comes along and adds a 3rd placement. So the 3rd placement would just require a new statement of work. So they don't need to go back in and extend out the MSA. They don't need a new MSA. they can just have a new statement of work. So it's much easier. So one of the issues that comes up all the time in the IT services industry is non-competes. Now, particularly it comes up when you have service providers and then sub-service providers and then sub-service providers. So there are all these layers. You might have, for example, a major IT service company that has 100 placements at Apple, for example, and then they don't necessarily go out and hire all 100 of those people. Sometimes they have a service provider, and that person. So obviously now the chain has gone from 1-to-1 to 2-to-1. So Apple being the end client, they have a service provider, and then that service provider has a kind of a sub-service provider, and then that company will oftentimes be subject to a non-compete agreement because the service provider doesn't want to lose that relationship with Apple. They want to be able to control the placements. They don't want these other companies jumping the gun and going directly to work with Apple. So what they do is they put non-competes in these agreements. But the problem with non-competes is that they're unenforceable in California. And this goes back to one of the basic elements of the contract, which is that contracts cannot be made against public policy or public interest. And the California Supreme Court has determined that non-competes are against public interest. So anything that's a restraint of trade would be against public interest and therefore would not be valid in California. Now, I understand that I think Virginia doesn't have that rule, for example. So in Virginia, you could put a non-compete in your contract, and in most cases it would be valid. I think there's some limited circumstances in which the non-competes would not be valid. And again, if you're in Atlanta, New York, or New Jersey, just double check because I'm not 100% clear on those. But non-competes are a tricky issue because on top of them not being valid in California, you also want to look to the choice of law provision to determine whether it can be enforceable if the employee, for instance, is not based in California or if the employer is not based in California. So if there is a choice of law provision in the contract that says, we're going to apply Virginia law, but the employee and the employer are in California, then there's an issue there, which is it really valid to apply Virginia law? And we'll get into choice of law provisions in a few minutes. And then the other question is, can you apply California law regardless? So non-competes are tricky. A lot of companies don't like them, and a lot of companies can't use them because they're legally not allowed to. So what can they do? What are the alternatives? So this goes to the next point, which is about intellectual property rights. So intellectual property right provisions of a contract are critical for the IT sector. They need to clearly set out what the definition of that intellectual property is and whether that intellectual property is being licensed, assigned, or just shared via not NDA or confidentiality agreement. So if there is an intellectual property rights provision in a contract in which a service provider is developing intellectual property for a customer, then that is almost always being assigned to the customer. So the intellectual property provision of that contract will say something along the lines of that the service provider hereby agrees and understands that the intellectual property that's being developed for the customer belongs to the customer, something like that. So the other issue with that is that the service provider also needs to be representing and warranting to the customer, or if it's a license agreement to the licensee, that the intellectual property that they're developing or licensing will not infringe on the intellectual property rights of a third party. And that oftentimes gets tied into the indemnification provision of the contract. So what you'll see is a rep or a warranty that the service provider is not in violation of the IP rights of another party. And then you'll see an indemnification provision that'll say, if the service provider or if a third party alleges that the intellectual property violates a third party's intellectual property rights, then the service provider will indemnify the customer. So you might see that. That's obviously very customer friendly. And it's a little bit tough for some service providers to make those reps and warranties, especially if they're using, open source software, or if they're using a combination of open source software and their own code. Obviously, if they're blatantly stealing other parties' intellectual property, then this would not be a very intelligent. It's just not good practice. So have a conversation with your client if you ever feel like that's the case. The intellectual property rights section of the MSA or other types of agreements should also deal with moral rights. So the moral rights related to the intellectual property, which include the right of attribution and the right of integrity. So those are a bit technical. And finally, what we've seen and what I've seen sometimes been utilized is a term that governs the transfer of the intellectual property rights to the payment terms. So I've had clients who had sections in their MSAs that says the intellectual property rights associated with the services only transfer to the customer after payment is made. Now, that's very favorable for the service provider, not so favorable for the customer. The problem with that provision is the enforceability issue. So in order for a service provider to actually go out and enforce that, they need to litigate to some extent and file a UCC for the intellectual property rights. So if you're trying to securitize that debt, whatever amount is owed with intellectual property rights, it's not very easy to do. So we've seen clients put this in and not be able to enforce it. So let's go back to this issue of non-competes and the relationship between non-competes and intellectual property. So the question that often comes up is, are customer lists intellectual property? Specifically, is it a trade secret? So a lot of customers, what they try to do, or a lot of our clients, what they try to do is they try to prevent their service providers or their sub-service providers from stealing their customers. And they try to do that by stating in the intellectual property section of the MSA or other agreement that the customer list is a piece of intellectual property and it belongs to them. So whether that's enforceable or not is an issue that we need to deal with. Under the Uniform Trade Secrets Act, the UTSA, the definition of trade secret is anything that's a compilation of information that has been protected in a certain way. So it's a broad definition, actually. But as it applies to customer list, what it needs to do is the customer list needs to do a couple of things in order to qualify as a trade secret. Number one, it has to be a compilation of written information in written format. Number two, it has to have independent economic value. So we see this oftentimes when a client does an acquisition, or if a client is doing a spinoff or something, that they assign a lot of value to their customer lists. and they sell the customer list as part of the transaction. So it has that independent economic value. It can't just be the basic identity and contact information. There has to be something else in there aside from just, the name, the address, phone number. It should be combined with some non-public information. Now, that's pretty easy for a lot of our clients because in addition to the identity, contact information of a company, of their customers, they may also have, the purchasing habits, the specifications, requirements, so that information in combination with the contact information would meet this requirement here. And finally, the party that's claiming intellectual property rights with respect to that trade secret needs to take steps to protect the confidentiality of the trade secret. So that might entail, so now obviously the relationship has broken down and you need to determine where you're going to litigate this matter. So most contracts, almost all contracts, have a choice of law section in the contract. The choice of law section needs to actually, you can't pick a random state. There needs to be some causal nexus between the state that you're chosen and either the transaction or the parties. So for example, let's say I'm a California corporation and I'm doing business with a Nevada corporation and the business is happening in Texas. So I can pick Nevada, I can pick California, and I can pick Texas. But I can't pick Utah, right? Because there's no reason why Utah law should apply here. Now, if I have a headquarters in Utah, for example, or if I have a significant presence there, and there's something about the relationship with Utah that governs, then I may be able to pick Utah. Now, the issue there is that there's this thing is called forum non-convenience, which means that if a significant portion of the case, including witnesses, evidence, is going to be outside of the state where the choice of law provision designates, then the defendant in this case can file a motion to quash, and we're kind of getting into litigation at this point, but they could file a motion to quash for forum non-convenience because 90% of the case happened in Texas and they want to move it all to Texas. So that's a possibility. Now, oftentimes you'll see in a choice of law section, you'll see two different statements. You'll see a governing law statement and you'll see a jurisdictional statement. And you could theoretically have a choice of law provision that says the forum that we choose for this for any disputes shall be California, but we're going to apply Texas law or Delaware law. That is a theoretical possibility. Now, would any party willingly enter into that agreement, knowing that California courts are not in a well-placed position to apply Delaware law? Probably not. In my opinion, I don't think that's a good idea. So usually you want the governing law section and the jurisdictional section of that provision to be the same state. So let's say, there's a dispute, but you're trying to either resolve it or it's moving forwards. So the contract itself should also specify the indemnities and the remedies of any disputes that come up. So remember earlier when I talked about the intellectual property rights of a third party. So if there is an issue like that, and in the indemnity section, one of the parties may try to mitigate that risk, particularly usually it's the customer, tries to mitigate the risk of intellectual property disputes coming from third parties through indemnification provisions. There's other reasons to have indemnification provisions. Oftentimes, the reps and warranties are required in order to enter into a transaction. And when a company makes certain representations and certain warranties, that's what they're showing to the other party to solicit that transaction. So when your clients are relying on reps and warranties in order to enter into a transaction, then they probably want to be indemnified in case that there's a misrepresentation of the reps and warranties. So what is indemnification? Just a quick note for those of you who don't know. An indemnification is when you agree to pay for somebody else's either damages or litigation fees or attorney's fees. So that's why in some contracts, when the party has a lot of leverage, they require the other party to indemnify them for certain risks that allows them to mitigate that risk. So there's different types of damages that could result from either a breach of contract or a non-performance of the contract. There is liquidated damages. So liquidated damages are generally, it's when a contract specifies an established amount that can be recovered if one of the parties breaches the contract or doesn't perform in it. And it might say something along the lines of, in no event shall aggregate liabilities exceed the aggregate amounts paid, blah, blah, blah. Oftentimes, liquidated damages provisions to a contract will say that, for example, if you're the service provider, it'll say the service provider in no event will be liable for anything in excess of what was paid to them. So if it's like a $20,000 contract and there's a breach in the contract, it'll cap the damages at $20,000. So the liquidated damages provisions to contracts are really great for a lot of parties, especially service providers in these relationships. But if you don't have one, if you don't have that provision, what you're left with is consequential damages. So consequential damages are essentially any damages that can be proven to have occurred because of the breach of the contractual obligation. So, for example, let's go back to the Apple scenario. So if there's a service provider, they have 10 placements at Apple, and then 2 of the placements really screw things up, and they breach not only the contract with the service provider, but they do it so badly that Apple decides, you know what, I'm really unhappy with this service provider, and I'm going to fire all 10 of these people. So the service provider loses its entire contract with Apple in that situation. So then the service provider can now sue for consequential damages, which is not just the value of those 2 placements that screwed up, it's the value of all 10 because it lost its contract with Apple. Obviously, the consequential damages can extend further out. So that's essentially contracts in a nutshell, especially MSAs. Again, I think it's really important to note, and the one takeaway I want everybody to have here is that non-competes are not enforceable in every state, and you may be able to overcome that with the intellectual property law section if you incorporate a customer list provision into that section. So that's it for me. Well, thank you everybody for joining this. It was really fun, and I hope you all took away some lessons here. And